Get it right, Terrio. Oh. Oh, kill him. Oh, kill him. Oh.
Yo, Dayne.
Yeah, was.
Yo, we're 17, right?
Yep. Good job, Chase.
I'm just saying that if we killed somebody right now, we'd be tried as minors.
Yeah, and then we'd be looking at premeditated murder and the death sentence.
Dude, not even. Haven't you ever heard of the Supreme Court case Roper versus Simmons?
Why would I know a Supreme Court off the top of my head? What even happened in that case?
Basically, a 17-year-old Christopher Simmons and two of his friends planned to rob and murder some lady named Shirley Crooks. In 1993, they met, but one of his friends kind of bailed on them.
Oh, dude, that's so unclutch.
I know. Anyways, Simmons and his friend Benjamin robbed the place and tied up the lady and took her to their state park and threw her off a bridge.
So, premeditated murder.
Yeah, exactly. In court, he confessed to the crime and even reenacted throwing her off the bridge on a video.
He had to have been given the death sentence. He had everything against him.
They did, but that's where the appeals began.
What was his argument? He completely confessed to the crime and even reenacted it on videotape.
Well, because of a previous case, Atkins versus Virginia, I think, they overturned the death penalty for mentally retarded people. So, in Simmons' defense, he stated that it was under the evolving standards of decency.
Let me guess. He argued that minors are shown to be more reckless because of their developing mental state, and that most of all, they're affected by outside forces and peer pressure. And basically he just said that it wasn't his fault because he was a kid.
But that was the only part of his defense. He argued that the 8th and 14th Amendments prohibited the death penalty for offenders who committed the crime under the age of 18. And we're 17 right now.
So what ended up happening?
Well, considering that only 7 other countries in the world have made minor execution legal, and since then they've all abolished it. The execution of minors in the United States was greatly tightened when they took the bare minimum age down to 16, in some states for wildly horrendous cases.
So, what's the minimum age in California?
Opinion of the court to announce in Roper against Simmons.
The present case involves a death sentence imposed on Christopher Simmons for a murder he committed at the age of 17 in the state of Missouri. Along with another juvenile even younger than he was, Simmons broke into the home of a lady named Shirley Crook. They bound and gagged her using ropes and duct tape, and then drove her in her own car to a railroad trestle spanning a river. Simmons and his accomplice bound Mrs. Crook more securely and then threw her from the trestle, drowning her in the waters below. There's no doubt that Simmons is guilty of the offense. There were aggravating factors of the crime, making it heinous and cruel. The Missouri statute has 3 separate provisions for aggregation, all of which the jury found complied with in the sentencing phase. And in addition to the cruel manner of the killing, it must be noted that Simmons planned it in advance. He told his friends, one who became the accomplice, that they could get away with it because they were minors. And even as the family was learning Mrs. Crook had been murdered, Simmons was bragging about the crime. A decade and a half ago in 1989, the court held in Stanford versus Kentucky that the Constitution allows states to impose the death penalty on an offender who was 16 or 17 years old when he committed the crime. In today's case, Simmons argues that we should depart from Stanford, despite its recent date, just as we have departed from an earlier rule regarding execution of the mentally retarded. 3 terms ago, in Atkins versus Virginia, we announced a categorical rule prohibiting the execution of the mentally retarded, overruling an earlier case, or departing from an earlier case. Simmons says we should announce a similar categorical rule prohibiting the execution of juveniles. The Missouri Supreme Court agreed with Simmons on that proposition and set aside his death sentence, and we now review that decision. The 8th Amendment, which applies to the states via the 14th Amendment, prohibits cruel and unusual punishments. In the interpretation of its terms, we have established the propriety and affirmed the necessity of referring to the evolving standards of decency that mark the progress of a maturing society. In the Atkins case, we held that our evolving standards of decency now require a categorical rule against executing the mentally retarded. As in Atkins, in today's case, our examination of evolving standards of decency proceeds in 2 steps. First, we examine the objective indicia of consensus. Second, we then must determine in the exercise of our own independent judgment whether the death penalty is a disproportionate punishment for juveniles. As to objective indicia, significant parallels exist between Atkins and this case. 30 states prohibit the juvenile death penalty. Now, this comprises 12 states that reject the death penalty altogether, and 18 states that maintain it but by express provision or by judicial interpretation exclude juveniles from its reach. Even in the 20 states without a formal prohibition on executing juveniles, the practice is infrequent. Since Stanford, 6 states have executed prisoners for crimes committed as juveniles, and in the past 10 years, only 3 have done so. The death sentence of the particular named defendant in the Stanford case was itself commuted by the state, so even he was not executed. 5 states have abandoned the juvenile death penalty since Stanford, and no state has lowered the minimum age for capital punishment. As in Atkins, the objective indicia of consensus in this case, the rejection of the juvenile death penalty in the majority of states, the infrequency of its use even where it remains on the books, and the consistency in the trend toward abolition of the practice, provide sufficient evidence that today our society views juveniles as categorically less culpable than the average criminal. The majority of states have rejected the imposition of the death penalty on juvenile offenders under 18. In accord with that view, we now hold that consistent with the 8th and
that you shine can't be seen. Baby, I compare you to a kiss from a rose on the grave. Ooh, the more I get of you, stranger it feels, yeah. And now that your rose is in bloom, a light hits the gloom on the grave. There is so much a man can tell you, so much he can say.